Right. Let's go on. David from the Natural Resources Defense Council.
Hello.
Here you go.
All right.
Yours.
Okay, thank you very much. Was fun to visit with you a couple of years ago. Last
Yes,
year, a couple of years
last
ago.
year. Yeah.
And you know, the hits keep happening, so there's more to talk about. This topic of, you know, the ending of the Chevron deference doctrine is difficult to talk about because it's in some ways it's kind of abstract, but it applies the changes that are going on in the way the Supreme Court and now lower court judges will be reviewing the actions of federal agencies. We're going to have very broad effects, and it's part of a bigger picture. But to make sense of it, I think I really need to start with what it is a reaction against, and then come back to what they have recently done. Well, so in you know, civics, we learned that there's a legislative branch, an executive branch, and a judicial branch of our government. The founders wanted to split those powers up in order to reduce the risk of tyranny. At least that's the way they thought that prior government structures ran the risk of various kinds of tyranny when they combined, or when all of the power is combined in one person or in one arm of government. So they decided to split them up. But that only began sort of a 250-year-old discussion about whether those are three separate circles that don't intersect, or whether there are three overlapping circles. In other words, is the legislative power entirely distinct from the power to execute the laws that's in the hands of the president and the agency? And is the judicial power entirely distinct from those two? Or do they in some ways overlap, especially the first two? And I think the best historical evidence is that right from the beginning, from the founding, the Congress was aware that, and it was an even smaller body then than it is now, that it couldn't do everything. It didn't have the bandwidth, the expertise, or the foresight to do everything. So right from the beginning, there's documentation that Congress would pass laws that give executive officers reporting to George Washington jobs to do, which were not as simple as, you know, just mechanically do what the law had set out for them to do, but there was judgment involved and some level of discretion that rested in the executive branch official, which some people would think of as, if you're making policy, you're legislating. But in other words, where's the boundary between the two branches when it comes to making what amount to policy decisions, as opposed to simply factual decisions? You know, if the policy was clear that all people with red shoes have to pay a tax, then you would just observe who had red shoes and charge the requisite tax. But there's more judgment involved in most of these laws. And it's only gotten more so in the 250 years since, as the tasks of government as the country gets bigger, the population gets bigger, the tasks confronting government get bigger, you know, the pace at which the modern world throws problems at us gets faster and faster. So, as I said, it started at the founding, but there was really in the middle of the last century, well, three times really, in the Progressive era at the beginning of the 1900s, in the New Deal era, and in the 60s and 70s. There were three bursts of legislative activity setting up new tasks for government and often new agencies to undertake those tasks. And I'm most familiar with the Clean Air Act. That's where my practice has been centered for 40 plus years, and it's now about 54 years old, the Clean Air Act. When I call them the founders in a different sense of the word, when the people who wrote the Clean Air Act in 1970 did so, they did not limit themselves to let's say, dealing with the 5 air pollutants that were well known at the time. They did that, but they also knew that science would identify new dangerous air pollutants. And they were able, with literally 4 or 5 years of intensive study, to know enough about the auto industry that they felt like they could themselves prescribe the percentage reduction of pollution from the automobile tailpipes. But they didn't know enough about the power industry and hundreds of other types of industries which emit air pollution. And so they knew they needed to invest the EPA, which was new at the time. Actually, the EPA was pulled together by Richard Nixon from different parts of the government that were all different parts of government up to that point. And they needed to give the EPA not only as clear instructions as they could, but some discretion to adapt to new circumstances. So, for example, they gave EPA the authority, in fact, the responsibility to list and then regulate new pollutants as the science demonstrated to the EPA administrator that they endangered public health or welfare. Welfare is a term that was defined to include basically every aspect of the environment beyond health, including climate change. So over the succeeding years, EPA added lead from gasoline to the list of regulated pollutants, and so on until in the when was it? In the early 2000s, they refused under the Bush administration to add greenhouse gases, carbon dioxide, and methane, and the other heat trapping gases to the list of regulated pollutants. And we sued along with states and others, and we won in the Supreme Court at that time, a ruling that these things are air pollutants, and if the administrator concludes that they endanger our health or our well-being, then they have to be regulated under the Clean Air Act. Well, so that's one theme I want to get across, that these laws the problems are beyond Congress to address at the level of detail that it takes to make a working pollution control program, or a working Food and Drug Administration, or a working Federal Communications Commission, or a working Federal Aviation Administration. So the Congress writes laws that give these kinds of broad directions and discretion. In 1984, which is 40 years ago, and that's when the Chevron decision came down. I was a young lawyer at NRDC, and I had brought, actually before that, in like 82 or 83, a challenge to one of the first decisions by Reagan's EPA, by Ann Gorsuch, the administrator of the EPA at the time. Ironically, she's the mother of the current Justice Neil Gorsuch. You know, you have, and it's become more accentuated over time, Democratic administrations are more inclined to try to implement these laws, you know, lean into them, and Republican administrations want to lean away from them. So Congress in 1977 had passed amendments creating an enhanced program for pollution controls on sources that were going to be built in the most polluted cities. What did the Reagan administration do? They changed the definition of a source so that it exempted about 90% of the objects that otherwise would have been subject to these pollution control requirements when built as new things. So to make this concrete, imagine that vase on the table is a boiler, and the table itself is an industrial plant that contains all kinds of other units of industrial activity. And under the rules, as we believed Congress has written them, if you added a new boiler, it had to be super well controlled, no matter what else was going on inside that plant. But under the EPA's rule that Gorsuch issued, the boiler was exempt from those rules if something else happened in the plant at the same time that reduced in overall emissions by almost as much. Almost a net equal situation. They said that in that case, there had been no pollution increase and no new source had been built to trigger these enhanced pollution control requirements. We sued. We won in the Court of Appeals in Washington. That decision was written by Ruth Bader Ginsburg when she was still on that court. But it was a screwy decision. There had been two prior decisions on the same word, what does a source mean, in two other parts of the Clean Air Act. And the way the DC Circuit works is you draw randomly a 3-judge panel. And for each of these 3 cases, we've got different 3-judge panels. We weren't involved in all of them, but the first one ruled as we thought it should, that the term was super clear and couldn't be evaded in this way, and struck down a regulation that Ford administration had issued that tried to do that. The second one came up during the Carter administration. The judges were more conservative, and those judges said, well, actually, in the context of the second use of the term, it's okay to have the lenient definition because that particular program was not intended to reduce pollution, but only to limit how much worse it got in the parts of the world like here, where it's better than the national pollution standards. And then we had our third case that I described. And Judge Ginsburg said, we can't, and this is correct under the way the Court of Appeals works, we can't overrule what the previous panels did, but we find a distinction. And the distinction is that this definitional change is forbidden in programs that are intended to reduce air pollution, and it's permitted in programs which are intended merely to restrain the increase in pollution. So this case, NRDC versus Gorsuch, was of the first kind, so NRDC wins. And the Reagan administration appealed to the Supreme Court. And I won't go into the complexities of it. The papers of Justices Blackmun and O'Connor, which became public years after their death, show that we almost won that case at the Supreme Court level. They were split, and there was a vigorous debate among the judges. But for some reason, they all coalesced around an opinion by Justice Stevens, which said, no, NRDC's wrong. This term is not crystal clear. There's wiggle room. There's ambiguity in this term. And when there's ambiguity, we don't want lower court judges to be substituting their own policy preferences for those of the agency. Congress and the executive branch are the ones that are elected by the people. The judges and justices are not. They don't have a constituency. So this is a policy decision, and it should be made within reasonable limits. If it's not off the wall, if this looks like there's 2 reasonable ways to interpret this language, we should defer to the view of the executive branch. And the Congress can change the law if they want, but this is between, basically, let's you two go out and hash this out. Judges are not going to substitute their own views about what's the best policy. And that became the law for 40 years, and it had very broad implications. It applied to every kind of administrative agency around, on any topic, any subject. Immigration law, food and drug law, communications law, and it applied in circumstances where where big corporate interests were at stake, and also small things like Social Security claim issues that would involve an individual, where the Social Security Administration would interpret the law one way, and the lawyer, the plaintiff, and the claimant, and her lawyers would say, no, I'm entitled to something that under the Social Security laws that the SSA is denying, and there would be a lot of deference accorded to the view of that agency, or the Immigration and Naturalization Service, about whether somebody could stay in the country. So some of these cases have the affect of the regulation of big business, and others have the affect of how does the government treat small time people with ordinary people. Justice Scalia was a fan of this doctrine. He said, he was the principal defender of this doctrine for at least 30 plus years. It ended up being, the case ended up being cited some, count is difficult to nail down, but some tens of thousands of times, between 10 and 18,000 times.
This is the Chevron.
The Chevron case,
Okay,
and the deference, the idea that you would, when the laws came up with a two-part test, when the law is clear, agencies got to follow it. Judges got to make the agencies follow it. But if the law has ambiguity, defer to the reasonable interpretations of the agency. Don't let the agency do something that's totally off the wall. Here's one example that I always like. The agents, I think it was under the Bush administration, it's one of the Bush administrations, the EPA interpreted the phrase total maximum daily limits, which is a water pollution term, to mean total maximum annual average limits. And the DC Circuit said, wait a minute, there may be some ambiguity to daily. It could mean midnight to midnight. It could be a 24-hour rolling average. There's a bunch of different ways you could define daily, but you can't define it as annual. That's outside the range of reasonable interpretation. So, we could win some cases for being outside the reasonable range. But most of the time, whether you were coming at this from the public interest side or coming at this from the corporate side, the courts, if they agreed the law was super clear, was unambiguous, then you could win on that basis. But if it most often fell into the category of, well, there's some ambiguity here, then the challenger would lose. The government would get the benefit of deference to its view. And so environmentalists lost as many cases under the Chevron doctrine, including the first one, the one I brought, as they might have won. We tended to like it when the government was in the hands of Clinton, Obama, and Biden, although it's not been used. It's fallen out of use. Biden's doing well, but not by virtue of the Chevron doctrine. So you could see progressive or more progressive administrations trying to interpret these laws, the ambiguity, to allow for doing more, whereas the Republican administrations would try to interpret the ambiguity as a basis for doing less or nothing at all. So I just want to get across that it's a neutral doctrine, and it empowered whichever administration was in power to interpret existing laws, narrowly or broadly. In the last 8 or 10 years, the conservatives, well, at first, the initial period, the Chevron doctrine got the plaudits of conservative scholars and judges. As I said, Justice Scalia thought this was a good arrangement. in part because he was conservative and he thought, you know, he actually wrote an article at one point explaining that you don't want to confine the Reagan administration too much because their mission is deregulation and you don't want the courts confining that. He was actually fairly even-handed. He would sometimes, vote to approve progressive regulations because the deference principle was a neutral principle and he believed in it. But, you know, there arose after Pharaoh, to use a line from the Passover Haggadah. There arose after Pharaoh a new set of conservatives, and they took great umbrage at the fact that, you know, the Clinton and Obama administrations could use this leeway for progressive objectives. And more specifically, and these are people who are funded by the Koch brothers network and the network of right-wing billionaires that Jane Mayer and others write about, who have been in so many different ways funding, you know, an army of legislators and of political activists to push for smaller government, to limit government. I'll come back to that theme in a minute. And so they recast this. They said, this is not a neutral doctrine. It's a big government doctrine. And we shouldn't have government that can restrict the liberty of individuals. Neil Gorsuch is actually a very, very strong exponent of this view. He's just written a new book about how we have too many laws. And what he's written about in a couple of these opinions is that it should be hard to pass laws and it should be hard to issue regulations because they restrict the liberty of those who are regulated. To which my answer is, what about the liberty of the people who are affected by the conduct that the Congress was attempting to address? The people whose liberty, whose life and health is damaged by air pollution, cut short by air pollution or water pollution. The people who are hurt by defective products that the Consumer Product Safety Commission is supposed to make sure are safe. Remember, the origin story of the Consumer Product Safety Commission had to do with cribs with slats that were so far apart that babies would get their heads caught in there and get strangled. So you needed a regulation that would limit the space between the slats. You know, and economic fraud from investors who misrepresent their company or its performance, and then they get to, if that's unrestricted, they get to bilk shareholders who invest under false pretenses. So these are the kinds of victims on the other side of the equation who have liberty interests. And when Congress passes these laws, it's not siding completely with the victims. The Clean Air Act says we should have air pollution standards, but it doesn't say we should have zero air pollution. So there's some balance between the strength of the standards and the cost of the standards, the protection they offer and the burden they put on the companies or whomever who have to comply with them. And that's the political balancing. I go back to that as, you know, Congress knew from the start it could not specify all this stuff at super level of detail. So it has to, if it's going to get done at all, it has to get delegated in some way to agencies. All right, with all that set up, what's happening now? So as I said, the right-wing movement, you know, anti-regulatory movement, has been gunning for the administrative state in many different ways for quite a while. There's a famous quote from, I'm blanking on his name, but he is one of the anti-tax advocates. He said, we want to get government small enough that we can drown it in a bathtub. So they've been very smart about deploying legal doctrines. And of course, now that we have 6-member ultra-conservative Supreme Court majority, it's time to activate all these doctrines. Some of them have been advanced in 10 years ago and so forth, and they bounced off the court because the court wasn't ready for them. Some of them are very arcane, like can administrative law judges impose penalties for violating labor laws, or does that have to go to a jury, to a judge and jury in an Article III court? Well, the court ruled this spring that the Securities and Exchange Commission can't use administrative law judges to impose those kinds of penalties. If you want to penalize the fraudulent investor, you've got to take him to court, which is much more resource intensive and will mean slower and less enforcement. There are a number of other ways in which, one of the cases decided this spring sort of destroyed a 6-year limit on how long after a regulation has been issued can you challenge it. And it used to be accepted under the Clean Air Act. It's really a short time. You have 60 days to challenge it. But under most laws, where you don't have a special provision like that, you've got 6 years. And it was, but somebody came up with the idea, well, what if a company was formed after the 6 years, but it's covered by this regulation? It isn't fair that it never got a shot to question the validity of the regulation. So a company, literally a gas station, called Corner Post, was ginned up to challenge a regulation limiting interest on credit cards, or fees on credit cards, that come back to the company that that you used your credit card, the gas station in this case. And the court ruled, well, it didn't exist at the time, so it gets another 6 years from its inception. And there's a bunch of other bad decisions from the perspective of making it harder for agencies to use existing laws and making it harder for Congress to empower them through new laws. And the mythology is that listen, if your liberty is going to be restricted, that Congress should do it itself. So that's the ultimate prize, is to say that Congress can't give agencies this job. It has to do all this work down to the minutia itself, which of course is impossible. So that's a recipe for drowning government in a bathtub. Now they're not there yet, and they may not get there. Back to this particular case. So in this case, the argument was, well, first of all, they went out and found a sympathetic small plaintiff. The real companies that are affected by EPA regulations, or big, they're the oil and gas companies, the big polluters. They didn't want Chevron out front the second time. So they shopped around and found 2 companies that are herringbone fishers. Basically, if you have a boat, you incorporate the boat as a company, and you go out and fish. And one of them has the unmemorable name of Loper Bright. I think Loper is just a family name. That's the name of the boat and the name of the company. And the other one is called Relentless, which is the better name. But it was the second case. So the doctrine that I'm describing is now called Loper Bright, not Chevron. And So and what happened here in these cases was the National Marine Fisheries Service sets catch limits for herring and for other kinds of fish to make sure people don't overfish and destroy the fishery. But you can't, there's no machine that you can put on the boat to, like a machine you can put in a smokestack to register how much pollution, or in this case, how many fish are being caught. The only technical means now is a human monitor. So then, and the law is explicit that the fisheries service can require human monitors go out on the local bright boat. But the question that was left unresolved was who has to pay for the monitor? Now, one of the courts said, well, look, when a company has to report a 10K form to the SEC, and that includes a requirement that it's audited, and the company has to pay for the audit, who's a human being. So this is no different. This law is ambiguous. We interpret it, we uphold the interpretation of the fisheries service that it has the authority to require the boat owner to pay the cost of the human monitor, the salary of the human monitor. That's the case that they took up. The statute doesn't actually speak to who has to pay for the monitor on the Atlantic herring fisheries or the Atlantic other fisheries. There's one Pacific fishery where it specifically says the boat owners have to pay. And that's a like Japanese super trawler type fishery where there's no real argument that the boat owner can't afford it. So the law being silent, the right-wing lawyers have a new law firm called the New Civil Liberties Alliance, which is supposed to sound like the American Civil Liberties Union, but it's the opposite. And their lawyers argued to the Supreme Court that the law is silent, and silence doesn't empower the agency, doesn't give the agency discretion to require this. It's not as though the law said the National Marine Fisheries Service shall have the authority to require boat owners to pay if in the judgment of the administrator, that's the right thing to do. Doesn't say that, it's just silent. And they also said this Chevron doctrine is just terrible because judges should be deciding these questions of law. These are questions of law. Judges should be deciding them. They're not policy questions that should be left to agencies. And the court bought this argument. I don't want to say hook, line, and sinker, even though that's a herring joke, a red herring joke. But hook, line. There's some parts of it which are, which I'll get into them, that are not as terrible as they first sound. So, but very strong proclamation that since these are categorized as questions of law, they are for judges to decide. Now, they do go, and Chief Justice Roberts wrote this opinion. He does say, in deciding these questions of law, you should pay attention to what the agency thinks and what the agency's rationale is. And especially you should pay attention if the agency's been consistent from the beginning, from whenever it was that this law was first passed and it first interpreted the law. If, for example, the Fisheries Service had said, I don't remember exactly when the fisheries law was passed, let's say in 1970, if they had passed a regulation in 1972 that said, we interpret this to cover to make the guy pay, then a long-standing interpretation by an expert agency is entitled to respect, not deference, respect. In other words, it would inform your view, but you, the judge, are still the one who decides if it's right or wrong. You don't any longer have to defer to a plausible or a reasonable interpretation that you think is wrong. And so the risk is that you go back to what Justice Stevens was trying to stop, which is judges having personal predilections, policy predilections, inserting those into his or her interpretation of the law. There are passages which are helpful. The Chief Justice says, of course, there are laws that delegate discretion to an administrative agency. And he says there's constitutional limits on that, which they don't go into. That's for future problems. But when Congress has done that, that's the law. The law has conferred discretion. And he gave examples. A couple from the Atomic Energy Act, one from the Clean Air Act, one from the Clean Water Act, which are very similar to the provisions that we're currently relying on to curb climate change and pollution. So, and then he said, in those circumstances, the judge's job is to fix the outer boundaries of what that discretion is. But then review what they did within those boundaries under a more deferential standard called arbitrary and capricious. Any lawyers here? Yeah. So when you stare at that couple of paragraphs a couple of times, I end up saying, that sounds a lot like the old Chevron step 2, when there's a range of interpretations and the agency's been within that boundary and not been arbitrary, then you defer. So at least in the places where Congress has been explicit in saying that, for example, the administrator of the EPA shall determine what is the best system of emission reduction for pollution coming from a factory and the level of emission reduction which is achievable through that technology, taking into account cost. Those are the kinds of statutes which he recognizes, the court recognizes, still confer discretion and allow for a range of action by the, in this case, the EPA administrator. But whenever you change the law, and you know, they overruled Chevron. They said that's just wrong, and then they reconstruct it in this other way. Whenever you do that, you destabilize something which was pretty well understood and stable for 40 years, and lower courts are going to go all over the place in determining what that means. And you're going to find judges in Texas, like the guy in Amarillo, his name is Kazmarek, who decided he knew better than the FDA about the mifepristone abortion pill. And the Supreme Court ended up overruling him effectively, but not directly. But you'll see like popcorn, and it's already happened. I mean, I'm told that there are already 40 or 50 decisions from lower courts citing this new ruling, the Loper Bright case. And we're going to have to rely on the appeals courts and then the Supreme Court to sort it out. And to give you a comparison, 2 years ago, the Supreme Court said, completely rewrote the Second Amendment jurisprudence and said, you know, you can't have gun restrictions that don't correspond to restrictions you could find at the founding. And then they had this case in, I think, New Orleans of the nutball spousal abuser who was threatening his wife with guns and shooting guns in public and shooting at merchants he disagreed with. And he had been put under a restraining order taking his guns away and claimed that under the Gruen decision that I was just mentioning, that he had a Second Amendment right. And the Supreme Court had to say, no, that isn't what we meant. There are some restrictions, you know, it doesn't have to be identical to something that existed in 1787. But there are parallels here that allow for the restriction of domestic abusers and nutballs like this. So we're gonna have to see how much spread and randomness and weirdness you get in the lower court decisions under the new Loper-Bright test, and see how much discord there'll be between the appellate courts. The Fifth Circuit is far more radical and right-wing than the Supreme Court. So the companies like to go to the Fifth Circuit to go for the most radical stuff they can get. And the Supreme Court ends up pulling it back a little bit. Even this court does. And the Supreme Court only takes like 60 or 70 cases a year. So it can take a long time. And many instances of misinterpretation can go uncorrected. Now, I'm almost ready to go to questions. I'm currently working on a case involving EPA's latest try to regulate power plant emissions of carbon dioxide. 2 years ago, the courts struck down a rule that had never gone into effect. But they interpreted it that the system of emission reduction that EPA had based the rule on, which involved emissions trading and shifting generation from dirty plants to clean plants intentionally, that was outside the authority that EPA had been given, although EPA could traditionally set technology-based standards that regulated the emissions of individual plants. So EPA went back over the last 2 years and rewrote the rules to follow the Supreme Court's statement of what they can do. Not, can't do this, but you can do that. EPA wrote a new rule to conform to the traditional technology-based approach, and the red states and the power industry are challenging that rule now. I haven't gone into the phenomenon called the shadow docket or the emergency docket, where the Supreme Court is increasingly, since 2016, allowing companies or other states to leapfrog over the appeals courts and get to the Supreme Court before the appeals courts have even ruled. I think even they are beginning to get tired of doing this. And anyway, the companies are trying it again. The Court of Appeals refused to put an injunction on the rules and explain why. It's called a stay. And all those petitioners have gone to the Supreme Court and said, this is outrageous, we need another stay. And our brief, along with the governments and some other allies, are due on the 19th of this month. I guess it's Monday. So Lisa's been watching me edit and schmooze with my co-counsel about this while up here. And we'll see whether there's restraint, whether there's any restraint. Because we think we have a damn good case that they have done what they've stayed away from what the court said they can't do. They've done what the court said it can do, and that the dispute is really not about law. It's about fact finding, and thus subject to this very deferential arbitrary and capricious test. And the court should refuse the emergency request to jump in and let the DC Circuit hear the case. The DC Circuit has put it on an expedited track already, so all the briefing at that level is going to be done in November, and we could have a decision as early as next spring. We'll see whether the appetite for hating on EPA and on the administrative state, whether there's a potential pause in that. I've gone through an awful lot, and I would welcome your comments and questions.
Question for you. Are you with the Twin City Law Firm or?
Oh, I'm with the Natural Resources Defense Council, which is a national environmental organization.
Okay.
And based in DC. And our DC's got offices around the country, but not in the Twin Cities. Our Midwest office is in Chicago. And I'm one of the staff attorneys. I've been there since the 70s, with time off for good behavior in the Clinton administration.
How does the
the change now affect our daily lives? What does it mean for me?
Yeah, so. I mean, that's a difficult question. I mean, it depends. First of all, it would affect your life if it means that a pollution control limit that you would benefit from fails. I'll give you an example. This is not so much about Loper Bright, but just the emergency docket. The Supreme Court decided in June to block a rule that the EPA had issued to limit the pollution, nitrogen oxides pollution, which causes smog, from upwind states that drifts into downwind states. And it was a 5-4 decision. Barrett dissented. She said, "This is nuts. This is why I'm beginning to think the tolerance for this is waning, even on the majority." And the grounds they gave are something that EPA can fix, but it would mean a year or two's delay in forcing the Midwestern power plants to cut back on the NOx emissions that are hurting the people downwind. If a judge in Texas, reversed the order of things, if the judge in Texas who messed with the mifepristone pill, he might have framed his decision as this is outside the authority of the FDA, because I interpret the law differently than the FDA does. If you, it might mean that you either get or lose the right to stay in the country. If you're an immigrant with a removal order from the Immigration and Naturalization Service that turns on their interpretation of the law. I think Justice Gorsuch would think that probably benefits the potential deportee, because he thinks the Chevron doctrine that he wanted overruled, what's the word? Put a thumb on the scale in the favor of the government. So if you had equally good arguments, the government would win because of deference, and that was unfair to the little people. Of course, it's also unfair to the billionaires. So, because federal regulation because federal laws cover so much territory and federal regulation covers so much territory, I can't give you a clean answer to the millions of ways it could affect your life. It depends what business you're in.
Yeah, on the new state PFAS law called Megan's Law, can we assume that it'll make it more difficult or impossible to implement that law?
Well, I'm not familiar with that law, but it's a good question. I was asked to come to a Midwest Legislators Conference in July to explore for Midwest legislators. I didn't think that was a natural audience. What the implications of this change in federal jurisprudence.
Oh,
And it turns out that different states have different rules of deference or no deference. Some states courts don't defer at all. Some states they defer very broadly. That's the first one. And I don't know where Minnesota falls. So, but first of all, this federal law change does not bind Minnesota and its courts. So Minnesota would just either already has decided or will decide on its own how much deference its courts should give to whatever agency it is that the Minnesota legislature has given these PFAS enforcement tasks to. So, I assume you got a law which tells I don't know what the agency is, a Minnesota agency to write some rules for what, let's say, water treatment plants, the treatment they have to have for PFAS. or maybe what restrictions there are on manufacturers or other companies using them.
Yeah, they're supposed to start restricting the manufacture and use together over an 8-year period, beginning the first of next year.
I mean, Congress can write laws, state legislators can write laws that are clear enough that you just, even if you're a damn good lawyer, you cannot successfully argue that there's ambiguity. Here's an example where it sort of worked against EPA. When Congress wrote the 1977 Clean Air Act amendments, and they created some permit programs for big new called major stationary sources. They actually put into the law that a major stationary source was one that emitted a year. Well, that term and that number, 100 tons, what of an air pollutant.
Okay,
That worked for the air pollutants we knew about at the time. Sulfur dioxide, nitrous oxide, nitrogen oxides, the original pollutants. 100 tons is a pretty good discriminator between a big source and a small source. But when the when EPA recognized that carbon dioxide endangers our health by causing climate change, we had a problem. Carbon dioxide is emitted in thousands of times greater volume than any of the other pollutants. So if you applied the 100-ton rule to facilities to decide whether they're subject to these tough pollution control requirements, you would end up controlling the Dairy Queen from the smoke coming off the hamburger, and that didn't work. So EPA said, well, this doesn't work, so we're going to change the number for the purposes of carbon dioxide. And Justice Scalia said, you can't. The number is in the law. You can't change it. So he came up with another way of getting the same end. He said, because we just can't conclude that Congress intended this program to work to apply to carbon dioxide. So carbon dioxide is exempt from that little part of the Clean Air Act. It wasn't a broad exemption. CO2 is still subject to Clean Air Act regulation, but just not there because the 100-ton limit makes no sense. So, if the PFAS, if the law you're talking about is written very clearly and says that the production and defines PFAS clearly, which is actually tough.
yeah,
And says nobody can make this stuff after 8 years. Well, if I were a judge, I'd say that's what the law is, and there's no messing around with that. Now, if there's ambiguity in the definition of a PFAS, there might be some scope for the agency to say it includes a big set of chemicals or a smaller set, and or for the company to challenge that decision. I'm just using this to illustrate the kinds of questions. I mean, you've given a good example. I hope that helps.
Yeah, David, something over 10% of the newborns in the Minnesota portion of the Lake Superior Basin have elevated levels of mercury in their systems, above what's deemed to be an acceptable level. There are fish advisories for eating more than a certain amount of fish in a week, and fish of over a certain size. Like, I don't eat locally caught fish at all because there's so much mercury. And that mercury is deposited primarily by airborne pollution. Is there anything in the decision that is going to harm what the EPA does now with regard to mercury? I don't mean to put you on the
Yeah.
spot.
No, I think the answer is no.
Okay.
But it's worth reflecting on the damage that the court did over the years to the delay in the mercury limits. When the Clean Air Act was amended in 1990, was a hazardous air pollutant program that covered mercury, among other things, that I helped to write. But one of the things that was done in legislative compromising was a special provision for power companies that said, before EPA can regulate the hazardous air pollutants from power generation, they need to make a finding that it's appropriate and necessary. Considering a bunch of factors, some of which made a little bit of sense. The same law had the acid rain controls in it. And the companies wanted EPA to have to determine that the acid rain controls did not, as a byproduct, do enough to deal with mercury, right? So EPA made its determination and the Supreme Court reversed it, saying, well, you need to take costs into account. You didn't take cost into account, you need to. And EPA went back, it took an, because this happened during the first controversy happened during the second Bush administration. The regulations were issued under Obama. The court decision came down, and then Trump administration intervened, so nothing happened. So the Biden administration finally put out the new regulations, and they're still technically under challenge, but the lawsuits are very weak. And in fact, what's happened is a pretty dramatic move away from coal-fired power, which is where most of the mercury came from. Almost all the mercury from the power industry came from coal-fired power. And so the deposition is going down, but the problem is it's already, lots of it in the lakes and lots of it in the fish. So this problem won't go away. But I don't think this is going to interfere with EPA's current regulations.
Okay, I'm gonna choose the last question. Does any of this threaten the IRA? Or is it just that we're waiting to see what happens at the election, to see what happens to the IRA?
Well, and the IRA is vast.
Yes.
And it's that's
we
the
have- what's the IRA?
Inflation Reduction Act.
Ah.
And the Inflation Reduction Act did a whole bunch of things apart from clean energy and the environment, like cap the cost of insulin and renegotiate drug prices and so on. So I'm not speaking to any of that. The environmentally relevant part of it is a set of very large tax incentive subsidies for clean energy. Everything from putting a heat pump in your house, a solar panel on your roof, to big investments by big industry in more efficient processes, big investments in renewable electricity generation and in battery development and deployment. And the biggest problem with the electric system is it used to be, if the electrons that run that light had to be produced within 2 or 3 seconds ago, right? There's no storage of electricity, even for hours. Now batteries are making it possible to load up, to generate solar and wind when sun is up and the wind is blowing, and store a good amount of it in the batteries to be discharged, and sent down the wires to run these lights at night. Anyway, lots of money for that, including money for carbon capture and storage technology that can be applied to the power plants. So, in addition, the Inflation Reduction Act amended the Clean Air Act to say, it was passed right after the court's decision striking down the last standards. Wind it up and do it again, write new standards, taking into account all these subsidies we have just created. That's what EPA has done. So, go back to your question. Mostly no. The tax credits, if the law says that you get a tax credit of X $100 for putting in a solar panel, there's not much leeway there. There is some leeway about where that solar panel came from, right? Or with the electric car credit, where the batteries, the lithium in the batteries came from. And there are some restrictions to try to keep Chinese stuff out from getting these credits because, we disapprove of China in various ways, whether it's the labor practices of the treatment of the Uyghurs or whatever it might be. And the countervailing thing is that the car companies have supply chains that it's gonna take them a few years to adjust. So car companies are actually committed to going to much higher levels of electric vehicles, but they need to be able to source the batteries and so on. So the Treasury Department is under some tension in interpreting the rules. Or interpreting the instructions they got when they write the rules about who's eligible or what equipment is eligible for the tax credit. It is possible that we could have lawsuits over those regulations, and then judges would decide whether the Treasury Department, correctly interpreted the relevant provision of the IRA. That's an example, but that could happen even if Harris is elected. Some judges could decide that the Biden-Harris regulations that are more accommodative to what the auto industry needs, in this case, what we also agree with, should be struck down. So it really, a lot depends on who appoints judges too. Obviously, that that Trump and Republicans have had an outsized effect on who's on the Supreme Court, and it could last for a long time. The lower courts, Trump appointed about 240 lower court judges, and Biden, by the end of this term, will have appointed almost the same, or maybe the same number. But of course, they're not replacing them. They're replacing older judges from the Obama and the Biden and the Bush, and even there's some that are still around from the Carter era. And those people are aging out and being replaced. So it matters who appoints the judges. It matters which court you go to. There's a lot of forum shopping going on. Fortunately, in my area, the Clean Air Act, national regulations have to go to the DC Circuit Court of Appeals. It's an unusual law in that respect. It was a very prescient decision by the people who wrote the law in 1970. And the DC Circuit has been relatively unaffected by Trump judges. There are a few of them, but they're not the craziest ones, and they're not in the majority. So you can even get the DC Circuit's order turning down the injunction to block the power plant standards was unanimous between two Biden appointees and Trump appointees.
No, I do have one more question. Can we book you for August 2025?
God willing.
Let's hope so. Let's thank David again.
Thank you.